All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in the in re termination of parental rights as to ZR. It's JV 220223. As you can see, Judge Campbell is not with us today, but she is watching the live stream, and she was with the panel this morning when we conferenced the case. And we also have our emails up, and if she has questions that she needs to ask, we will make sure those are asked during our argument. As you know, we record and live stream these proceedings, so please give your name and introduce yourself and your client before you begin. You each have 20 minutes per side. You're not required to use all of that time. We do require that you keep your own time, so if you want to reserve some time on the clock, you need to keep that yourself. Please keep in mind, as I said, we have read your briefs, we've studied the record, and we have discussed the case in conference. And now, counsel, you may proceed.
Good morning. Kathy Sandweiss for Appellant Mother. With me is my partner, Roger Cohen, and the mother and her family are here in the courtroom today. I really want to focus the court on two legal issues. The first is interpretation and application of ARS 8535C, because the language of that statute is clear and unambiguous, and respondent expressly consented to termination of his parental rights and expressly waived notice. And then the other issue that I'm going to focus on is that respondent was represented by counsel in the evidentiary hearing, at the termination hearing, and he therefore submitted to jurisdiction of the court. So I'm going to start with statutory interpretation. If the courts are faithful to the text of 8535C, there was no need for formal service because respondent executed a notarized waiver. Any other reading of that statute would nullify subsection C. Now, Commissioner Popko, we know, concluded that ARS 8535C does not apply to waivers concerning service of the termination petition. He says the only effective waiver of service of a termination petition must conform with Civil Rule 4.1. But I know the court has read the statute, and the language of subsection C makes no reference at all to Civil Rule 4.1 or any additional waiver requirements, and we must follow the text of this statute. This court has reiterated recently in the Snowball case, the goal in statutory interpretation is to give effect to the words that are used by the legislature. And yes.
Counsel, so if I could direct you to Rule 352, the Juvenile Court Procedural Rules.
Right.
Subsection C directs that at the initial termination hearing, the court must, and this is for, determine whether service of process has been completed pursuant to Rule 351 or waived as to each party.
Right.
And so my first question is that jurisdictional?
Well, that's an interesting question with actually two answers. When you get to the issue of jurisdictional, that actually gets then to my second issue here, which is that...
Is that jurisdictional?
Well, it is jurisdictional, but jurisdiction, remember, was met because respondent appeared through counsel at the hearing. And so when you look at Rule 4, Rule 4 specifically says that there are certain ways to waive service, including appearance through counsel.
Understood. And so where in the record did the court, the termination court, make that determination?
At the beginning of the hearing on February 9th, Ms. McLaughlin was introduced, and she said, "Good morning, Your Honor. Melissa McLaughlin, assigned counsel for father." And then The court said, in reviewing the petition, it does appear that father was consenting to the termination. Ms. McLaughlin, have you had the opportunity to talk to your client at all? Ms. McLaughlin says, thank you, Your Honor. I attempted to make contact with my client. He sent both myself a notarized letter as well as provided one to mother. So then when we look at the notarized letter that respondent sent, he specifically gives his court-appointed counsel instructions. First of all, he specifically acknowledges, he says, you were assigned as my attorney for a case number, states the case number. I received the notice in the mail about the hearing date. I no longer want to be contacted on this matter. And this is, by the way, this is Exhibit 21 to Mother's Statement of Facts in the summary judgment proceedings. He says, I am aware what I signed. I understand what it means. I will not be attending the hearing on February 9th. And so we have full acknowledgement both from respondent and from his counsel.
Right, so where does the court make that finding? And then, why don't we jump forward to subsection D1, which says, at the conclusion of the hearing, the court must enter findings concerning notification and service and the court's jurisdiction over the subject matter and persons before the court. So my question is going to be the same thing. Where in the record does the court make any findings or discuss in any way, the question of subject matter jurisdiction?
The court doesn't use that language, but on page 17 of the transcript, the court says, I do think the father has at this point consented to the termination. He has signed the consent, has noted that he does not wish to consent, that he does not wish to contest the termination. So that gets us back then to the statute and the language of 8535C. So there are two different ways to do these termination proceedings. One is where it's a litigated proceeding, and that would be covered by subsection A. The other is where there is consent to these proceedings, and that would be covered by subsection C. And the Superior Court, the judges who are in the juvenile courts do this all the time, where there's a specific process where there's notice and appearance that's waived, and not only that, but there's specific requirements in this subsection as to what it is the consenting parent is waiving. And that is acknowledging by the person signing the waiver, the face of the waiver contains language explaining the meaning and consequences of the waiver and termination of parental rights. And then the parent who has executed that waiver shall not be required to appear. And when we look at these documents that were signed by respondent, they fully comply with that statute. There were two documents, consent to termination of parental rights and waiver, and respondent specifically stated he agrees to relinquish and give up all of his rights to care, custody, and control of the minor child. He says, I understand that upon entry of the order of termination, all of my legal rights and privileges will cease to exist. I will no longer be the child's parent. And so what this statute and this subsection contemplates is a smooth proceeding so that there's no requirement, no secondary requirement, that after going through this somewhat burdensome process of waiver of notice, there's no need to then comply with or apply subsection A, which would be service, because notice has been waived. And in this case, we sort of have what we call belt and suspenders. We have all kinds of things happening in this case that show actual notice and actual opportunity to appear, and we have compliance with a whole variety of rules. So we have compliance with subsection C, full compliance with the language of that statute. we also have appearance by, and it's known, I guess, as to the question of whether the first judge actually entered an order where she stated on the record that she has jurisdiction.
Well, her minute entry says she has jurisdiction, but the juvenile rule asks her to make findings as to her jurisdiction. So it's just saying I have jurisdiction with nothing else in the record to point to where the basis was for that when the rule in fact tells her that she has to make findings. How are we to take that?
Well, when you look at the Arizona Supreme Court case of Montano, it says it is a rule of ancient and universal application that an appearance by a party who has not been properly served has exactly the same effect as proper, timely, and valid service of process. And then it goes on to say, if a party appears in person or by attorney, he submits himself to the jurisdiction of the court. So we have that. He submitted himself to the jurisdiction of the court by directing his attorney not to object to the proceedings, not to contest termination. He specifically wrote her a letter, he signed the letter, it was notarized, and he was aware of the hearing. He was aware in a couple of different ways, actually, and he acknowledged it in the letter to her. But remember, in this case, the court also sent out, if the court will look at Index of Record 6, the court sent out a distribution of notice, and it was addressed to him at his address on Redfield. So there was no further requirement. And I believe that the juvenile rule would take effect only if there was a requirement under subsection A of 8535, because all of these rules and statutes, remember, are read together. They're all in the same subject matter. And the cases all say that when there's a set of rules, a set of statutes that relate to the same subject matter, they must be all read together. And in this case, there would be no purpose. There would be no purpose to having this subsection C as a practical matter if there had to be formal service under subsection A.
Counsel, do we assign any weight to the fact that he waived something that hadn't been filed yet, that we don't know? I mean, in this case, it was that he was agreeing to the severance and abandonment, but if for some reason she had filed a petition that had wild accusations as to his sobriety, his abuse, his neglect, something that would have more weight, is there any value we should assign to the fact that should you be allowed to waive something you haven't seen that could have other legal repercussions for you that you wouldn't know?
Right. That's an excellent question. And under that hypothetical, I would say that in that case, respondent certainly would have an opportunity to move to have it set aside because he was not knowingly waiving. But in this case, fortunately, there was no unfair surprise. In fact, when the court looks at Index of Record number 1, the petition, it absolutely tracks exactly what it is respondent waived. And so there were no surprises. And so, yes.
There didn't end up being any surprises, right. But at the time that you're saying he waived, he did not have that information. She could have written anything in that petition, and you could have made the same argument that whatever it was, he'd acknowledged that I waive what hasn't been filed yet. And I just wonder from a due process perspective if that's something we want to encourage.
Well, there's no requirement in subsection C that the respondent or that the consenting parent be provided with a copy of the petition. But I would say that under those circumstances, if there is something in the petition, allegations of sexual abuse or something that is unexpected that is not particularly and specifically set forth in the waiver, that would be grounds to set it aside. But in this case, the waiver is very specific. The consent is very specific that he is consenting to relinquishing his rights to the care, custody, and control of the minor child, and that he understands he will no longer be the child's parent. So again, the waiver, the consent and waiver, comply with the specific requirements of subsection C, where there be language explaining the meaning and consequences of the waiver and termination of parental rights. And in this case, then when we go to the language of the petition, there is nothing more than that. There's no surprises in that petition. So under that hypothetical, I would say we can't necessarily create a rule for every circumstance, but under the circumstances of this specific case, with the language of this waiver, the consent and the waiver of notice, and then the language of the petition, respondent did knowingly waive all rights. He consented to termination and he waived notice. And actually, when you look at the language of his consent and waiver, he actually did waive service, although again, that's not required by subsection C. Yes.
So, counsel, let's say we would agree that there's some sort of fact question and summary judgment wasn't appropriate. Wouldn't we just remand for an evidentiary hearing to swear in the witnesses and let a judge hear them?
That's right, if there is an issue of fact. Now, remember, in this case, Commissioner Popko assumed the genuineness of all of the documents, and I'm not quite sure what the issue of fact would necessarily be, but that's right. In fact, this case was determined on summary judgment, and so if the court finds that there are issues of fact and determines that there is not a clear legal issue to reverse on, then of course the court would remand for further findings. I would like to reserve the balance of my time for rebuttal, but what I would ask the court for is, number one, to reverse this order granting summary judgment and allow the termination order to stand. But there's something else that's a little bit unique about this case, and that is that there are proceedings going on right now in juvenile court. And there are trials going forward. There's a trial in April. Respondent's deposition actually is being taken tomorrow. And I would ask that if the court cannot have a full written decision within the next couple of weeks, that the court at least issue an order letting the parties know where it is going as far as setting aside Commissioner Popko's order. Thank you.
Thank you. When you're ready.
It's really close. Good morning, Your Honors.
Morning.
My name is Amy Sells. I'm with the law firm Tiffany & Bosco, here on behalf of the respondent, Jake Vernig. Although we're discussing procedural rules today and statutes, the core of this case really is about a father who has been fighting for 2 years to maintain his parental rights with his daughter, who is now 4 years old. What I'd like to do is start by defining some key terms because I think it's important, and then I'd like to get into the statute and talk about its operation. I think that the fundamental flaw with Mother's argument is that she seems to be conflating service of process or waiver of service of process on one hand and waiver of notice and appearance on the other hand. These two concepts have completely different purposes and effects. Turning to waiver of service first, if you look at Black's Law Dictionary, for example, it defines waiver of service as, quote, a defendant's voluntary submission to the jurisdiction made by signing an acknowledgement of receipt of the petition and stating that he or she waives all further service. So you have the defendant actually receiving the petition and then submitting to the jurisdiction of the court, and by doing so, they're not waiving any defenses whatsoever. Now, waiver of notice and appearance, on the other hand, is something completely different. Again, if you go to Black's Law Dictionary, it means a coming into court as a party, a defendant's act of taking part in a lawsuit. And so What this means is, if you are saying as a defendant, I don't want to receive notice of any further proceedings in this case, that means I'm not going to appear, and I am acknowledging that the consequence of all of that, my not appearing, means I could lose my parental rights. So when you turn to the statute 8-535, you see that Section A pertains to waiver of service of process. Section C pertains to waiver of notice and appearance. So if we talk about subsection A, it says that notice of the initial hearing and a copy of the petition shall be given to the parents of the child as provided for service of process and civil actions. So by
Counsel,
incorporating...
If I could just direct you to that rule again, the juvenile court rule that says the court, and there are two things. One, at the initial termination hearing, the court must determine whether service of process has been completed pursuant to Rule 351, which means serving the petition to terminate, or waived as to each party. And then the second one says the court must enter findings concerning notification and service and the court's jurisdiction over the subject matter and persons before the court.
Yes.
So my question to you is, where in the record did the termination court, the first court, either make that determination or make those include those findings?
At best, I think in the minute entry, there's a conclusory, a conclusion that the court has jurisdiction, but there are no findings to explain how it is that the court could arrive that it had at the determination that it had jurisdiction.
Well, and it's a sentence fragment. In the minute entry, it says the court has jurisdiction, the child being in Maricopa County or
Yes.
But is there somewhere else that we can look to find either the determination or the findings?
Not that I'm aware of, Your Honor.
And if the court says during argument, I find the father has waived his parental rights, I'm not sure if that's what they said, is that also, I guess you were talking about the different gradation, the different types of waiver. Is that waiver, a waiver of parental rights, also different than a waiver of a service of petition? So if the court makes a finding
Yes.
and says, I find there is a waiver of whatever the court said at the hearing, I think it was, I don't know, let's say it was parental rights, does that satisfy the rule requirement that you determine whether there's been service of process that has been completed or waived?
No.
Or does that meet the second rule, which requires findings?
I'm a little bit confused here, but maybe we could talk about it a little bit. I think that the court, by just saying that I find that there is a waiver, might be saying that I have found that there is a waiver of notice of appearance, and may have found that there was therefore a waiver of the right to receive notices, to appear, and an understanding that parental rights might be terminated. However, just because there is that sort of a waiver does not necessarily mean that there is a waiver of service of process. It doesn't mean that the court, in fact, had jurisdiction to enter any sort of an order against this individual. Does that answer your question?
Yeah, I want to see, I got to go, I want to see what the judge said, but if the judge says, I find you have waived your parental rights, is that enough to meet the requirements of the rule, which says you need to find whether service of process or waiver as to each party, waived as to each party, and then entering findings. So it's kind of downstream, like as an economic, you're terminating the rights, and does that subsume and waive everything that precedes it, including service of process?
Is it that?
Right, and so the court says the court finds that father has signed a consent, and then during the hearing, though, the court says something like, I do find that father has waived and I just don't have the language. But I think it's something like his parental rights. And so obviously that's downstream. But does that subsume and waive everything?
I would say no, it does not subsume the obligation to still obtain jurisdiction over the defendant by service of process.
And what about their argument that the attorney's appearance did that?
The attorney's appearance did not do that. And first of all, I did not see in the briefing anywhere where they made a clear argument that the father voluntarily appeared at the initial hearing through his counsel, and therefore service of process did not need to be effectuated. I didn't see any such argument in the briefing. But to answer your question, I think if that sort of an argument were made, the answer would be, well, I think the argument actually that was made is that the court-appointed attorney had apparent authority given by Jake to act on his behalf. And so where did that authority come from? It would at best have to be the December 29th letter. And if you look at the letter, it starts out by saying, I recognize that you are my court-appointed attorney, and there's some text in between, and at the very end he says something to the effect that I recognize that there is a hearing. But nowhere in there do you see him actually manifesting any sort of an assent to the court-appointed attorney, asking her to take any sort of action on his behalf or affirmative action. And this being a court-appointed attorney, too, just by mere fact that she appeared at the initial hearing doesn't really mean much either. I mean, she would have appeared at that hearing anyway because she's the court-appointed attorney. She didn't, in other words, appear there because he had asked her to appear on his behalf and take certain conduct on his behalf. So I would say that there's not apparent authority or any sort of authority for her to be appearing on his behalf, making any sort of representations on behalf, and for the court to be entering any sort of decisions based upon her appearance. If I may, we were talking about subsection A of the statute, and how it says that notice of the initial hearing and a copy of the petition shall be given to the parents of the child as provided for service of process in civil actions. So by incorporating the rules of civil procedure, the statute is incorporating Rule 4 as well as Rule 4.1. Both of them talk about service of process. Now, Judge Popko had said that Rule 4 doesn't apply because if you look at the former juvenile rule, which was applicable then, 64D3, it specifically refers to service under Rule 4.1. It doesn't mention Rule 4. I agree with him, but I will also note that even to the extent that Rule 4 does apply here, it doesn't harm father's position. Rule 4 talks about waiver. Rule 4.1 talks about waiver. Under Rule 4, it says that waivers have got to be in writing. They've got to be signed. They've got to be filed with the court. Rule 4.1 goes to further lengths in explaining what needs to take place when you're requesting waiver of service of process. Rule 4.1c says that request must be accompanied by a copy of the pleading to be served and 2 copies of a waiver form prescribed under Rule 84, Form 2. And then Rule 4a3 says that service, regardless of what type of service it is, it's got to be accompanied by a copy of the pleading. And so here, when you look at the documents here, the October 7th waiver of notice and appearance, the October 7th consent to termination, and the December 29 letter, none of those actually contain an acknowledgement of receipt of the termination petition. And looking at the juvenile court forms, which I think are not governing binding here, but they are persuasive, there is an actual acceptance of service form that's provided, and it's called acceptance of service 4F.
Couldn't father waive that service of the prospectively, just I want nothing to do with this, and keep me out of it? Maybe a poor decision, because it might allege homicide. Who knows? That have very serious ramifications. But can father do that?
Can father
prospectively waive service of the petition to terminate?
I don't think that is a very how can one waive service of a pleading? Oh, I see what you're saying. To prospectively waive. No, I mean, it's just completely contrary to the rules. The statute itself, the rules, they require that if you're going to be receiving service of process, you're going to be waiving service of process. Black's Law Dictionary even contemplates that you're receiving a copy of it. That's the whole purpose of waiving service, is to say that I'm agreeing to forego the time, expense, delay of formal service, and I'll just go ahead and take the documents from you personally and sign off on this waiver that acknowledges that I have received this document. Does that answer your question?
So a waiver of service would still require that father have received the operative document, the charging document, whatever you want to call it.
Yes.
In order for all of this to have been of effect.
Yes, absolutely. And so I was going to mention the juvenile court form, too, that's called acceptance of service 4F, and 4F I think is relating back to or referring to the civil rules 4F, and that pertains to acceptance of service and waiver of service as well. If you look at that form, it says that defendant accepts and waives formal service, and it also contains an acknowledgement that the defendant is receiving these documents, and there's boxes you can check off acknowledging that you've received the petition, the notice of hearing, and the order setting the initial hearing. So for those reasons, we don't have waiver of service of process under Section A here. Moving to Section C, that pertains to waiver of notice and appearance, and that section does not incorporate the rules of civil procedure, and with good reason, because Section C contemplates a completely different type of waiver, and Section C then talks about what the requirements for that type of waiver would be, and that includes a notarial acknowledgement as well as language that acknowledges the consequences of a notice or a waiver of notice and appearance. It's not difficult to figure out what that consequence type language would be. I'm not receiving notice, therefore I'm not appearing, therefore I understand and acknowledge that my parental rights might be terminated. And again, talking about the juvenile court forms, there's an actual court form that is entitled Waiver by Parent of Notice of Hearing and Appearance. And if you look at that form, there is that consequence language in there, and it says, I understand that waiving notice and or failing to participate in these court proceedings may result in a court order terminating my parent-child relationship. But if you look at the October 7th waiver of notice and appearance here, there's no such consequence language in that waiver, and so even that is not a waiver of notice and appearance under subsection C.
So, counsel, sorry to direct you back, but I found in the hearing what the court says. The court says, obviously, I do think that the father has, at this point, consented to the termination. So it wasn't, I guess, waiver, but is that finding that he's consenting to termination enough?
There needs to be formal service of process in order to establish the court's jurisdiction over the defendant.
What about, is that enough as far as the court's obligations under the rules to make a determination whether there was service of a petition to terminate and findings as to its own subject matter jurisdiction?
I think that there would need to be, and I'm sorry, I didn't catch all of the, was there a basis for the court's finding that there was a waiver?
It just says, I think, obviously, that father has consented to the termination.
I see.
So again, it's like I said, it's downstream, and it's sort of assuming, arguably, that all of, everything has been fine to that point and making. And so is that enough for a court to meet its obligation under the rules?
I'm sorry, I feel like I'm saying the same thing over and over again, but I truly do believe that the court simply doesn't even have jurisdiction to enter an order terminating his parental rights unless there has been proper service.
Okay,
so they can make these findings, however, the order itself is void for lack of jurisdiction.
Okay, so what you're saying is, in order to conclude that father has consented to termination, the court required subject matter jurisdiction to even enter that area, that space.
That's exactly it, Your Honor. So setting aside where am I? I see. I have 3 minutes left. Setting aside the statute, the fundamental principle here is that without proper service, a court has no jurisdiction over a party, and that is a rule that was actually cited to in the special action opinion in this case. And so beyond the statutory compliance, Mother also ignored the court's December 15th order in which the court ordered Mom to serve Dad, and we know that there was no personal service. Mother may try to argue that by virtue of her handing the father the folder that contained, among other things, a termination petition, that was personal service. But we know that it's not. Mother is not a certified process server under Rule 4D, and so that was not effective service. And we know also that there was no service by assent via waiver or acceptance of service, because in none of these documents is there an acknowledgement of receipt of the actual petition or termination petition.
So why isn't there a question of fact when we have an allegation that Mother handed a folder, and I understand what you just said is that Mother wasn't a process server. So is that your answer, that it's not a question of fact that we would have to send back for an evidentiary hearing because Mother lacked the standing to perform that job?
As a matter of law.
As a matter of law.
Correct.
Okay.
Yep. And Mother would say that Father had actual knowledge by virtue of all of these documents, but actual knowledge is just one piece of the puzzle here. Now, notice an opportunity to be heard. The due process concept is just one of the reasons for service of process, and the other component to that is jurisdiction. And I think that this is especially important in cases such as this one, where the liberty interest at stake is so critical. Parents have a fundamental liberty interest in the custody, care, and control of their children. That is something that the Arizona Supreme Court acknowledged in the Alma S case, Alma S versus DCS. And then also in that case, the court cited to a United States Supreme Court case that had, I thought, very poignant language that says, parents faced with irretrievable destruction of their family life have a more critical need for procedural protections. And I think that's exactly what's going on here. When Mother says, well, Father's just being hyper-technical and he's trying to use the rules as a sword. Well, given the liberty interest at stake, I think that this is the sort of case where we have to really ensure that there is strict compliance with the procedural rules and specifically service of process. And with that, Your Honors, if you don't have any further questions, I will.
Okay, thank you.
Thank you very much.
No, when you're ready.
All of these rules and statutes must be read together, and they must be read in conjunction with Rule 4F, 3, A, and 4. All right, subsection Rule 4F 3A says, in open court, a party on whom service is required may, in person or by an attorney or authorized agent, enter an appearance in open court. Then we get to subsection 4, effect, waiver, acceptance, and appearance under F1, 2, and 3 have the same force and effect as if a summons had been issued and served. So when we look at the juvenile rule, we must read it in conjunction with all of these rules. And as to the court's question about is there an issue of fact, well, certainly if there was any issue of fact as to whether or not Ms. McLaughlin had authority to act on behalf of respondent, then this was not a summary judgment case. Now,
well, that's a good question. I mean, it's a good point. So you're stressing Ms. McLaughlin, but didn't she say during the course of that hearing that she's never spoken to her client and she just received a letter?
That's right. She tried to. She said in this hearing.
Right, but she's
She
never
couldn't-
spoken to him, he didn't hand her a letter, but the court should just move forward and assume that those apply in a termination proceeding?
Because he gave her a letter where he said and acknowledged, "You are my assigned attorney," and then he specified that he had notice of the hearing and he was not going to appear, and she said, "I attempted to make contact with my client." So we are now exalting so much form over, again, so much substance. We have a written, notarized consent from this man stating it's in the best interest of this child that my parental rights be terminated. He stated that in a notarized document that, by the way, his notary had him then sign her notary book and collected his driver's license for. So, long after the fact, for whatever reason that we don't know, he came back and moved to set this aside. But there was no unfair surprise. The petition tracked the language of his consent. He knowingly gave up his parental rights to this child. And so, again, I would ask the court to set aside Commissioner Popko's order and allow the original termination order to stand as written. Thank you.
Thank you. Thank you for your arguments. We'll take the matter under advisement and issue our decision in due course, and the court stands adjourned.
Thank you.